Kenya fought the alleged crimes against humanity charges facing its president at the International Criminal Court on at least 4 fronts. On a bilateral level, at the very initial stages of President Kenyatta's case, Kenya went on a diplomatic charm offensive across the continent, and this involved Kenya's top leadership and diplomats engaging the African Union and African leaders on the dangers the court posed to Africa's sovereignty. The African Union headquarters in Addis Ababa, Ethiopia, became a major theater where the continent fought what it viewed as a racist court targeting Africans. On various heated sessions of its sittings, African leaders made far-reaching pronouncements and declarations on the Hague-based court. Ambassador Macharia Kamau, the Kenyan permanent representative to the United Nations, wrote to the United Nations Security Council asking it to terminate the ICC cases against President Kenyatta. Now, Kenya appealed to both the United Nations and the court itself regarding the admissibility of the case. The Kenyan case prominently featured during last year's Assembly of State Parties on Rules of Procedure and Evidence. Kenya also managed to push for a new rule, number 134, which allowed for excusal of sitting heads of states and other government office holders from continuous presence during a trial. Now, at the height of the agitation against the cases facing the Kenyan president at the court, the African Union became a huge stage in the battle against a court African leaders termed racist and biased and out to embarrass and humiliate the continent. So when Kenyatta's case dramatically collapsed last week for lack of evidence to prosecute it, Africa felt vindicated. CCTV's Girum Chala now looks at the African Union's response.
The chairperson of the African Union Commission, Nkosazana Dlamini Zuma, said withdrawal of the charge was a victory not only for President Uhuru Kenyatta, but for the entire African continent. She observed that the president now has time to focus on his constitutional duties of leading Kenya and its people. The African Union's statement, in addition, said, and I quote, "The African Union is, however, mindful of the fact that the International Criminal Court's trial chamber will still need to make a decision regarding the prosecutor's withdrawal of the charge against the president." Some AU officials I spoke to said this is a clear indication that the International Criminal Court's operations, especially with regard to Africa, were flawed. According to the African Union, Bensouda's move vindicated Africa's position that sitting heads of state should not be prosecuted. Analysts, on the other hand, say African states must not be distracted by this small victory. They should continue their quest of collective withdrawal from the Rome Statute. Currently, there are around 30 African signatories of the Rome Statute. Grumtala, CCTV, Addis Ababa, Ethiopia.
So just how exactly did Kenya end up at the International Criminal Court? CCTV's Clementine Logan walks us down memory lane.
In December 2007, a disputed presidential election plunged Kenya into chaos. The widespread and systematic violence that ensued over 2 months left around 1,300 people dead and over 500,000 people displaced. The international community stepped in an attempt to broker peace under the leadership of Kofi Annan and the panel of eminent persons. The result was a grand coalition government led by then-President Mwai Kibaki and Prime Minister Raila Odinga. Following the conflict, evidence arose suggesting that much of the violence had been premeditated by politicians and community leaders at the local and national level. In October 2008, an inquiry led by Judge Philip Waki, known as the Waki Commission, got underway. July the following year, the names of 6 individuals deemed most responsible for the post-election violence was sent to the prosecutor of the International Criminal Court. This followed 2 failed government attempts to establish a tribunal. Then ICC prosecutor Luis Moreno Ocampo met with Kibaki and Odinga on the 5th of November 2009 and announced the opening of the ICC investigation. 6 suspects said to hold the highest responsibility for alleged crimes against humanity during the post-election violence were named. They became known as the Ocampo Six. On one side were Uhuru Kenyatta, at the time a cabinet minister and now Kenya's president, Francis Muthara, head of civil service and cabinet secretary, and Hussein Ali, a police commissioner. On the other side, William Ruto, also a cabinet minister at the time and now deputy president, Henry Kosgei, a cabinet minister, and Joshua Sang, a popular radio journalist. Kosgei, Muthara and Ali's cases have since been dropped, and on the 5th of December, President Kenyatta's became the fourth, the Office of the Prosecutor citing insufficient evidence. The ICC's efforts to bring justice to the victims of Kenya's post-election violence are now steeped in controversy. Clementine Logan, CCTV.
Now, after the break, my guests on the program will look at the political and legal implications for the ICC following the collapse of the cases facing Kenya's President Uhuru Kenyatta.
Anyway, I'm very excited, by the way. So,
I've waited for this moment for 6 years. The words of a relieved Uhuru Kenyatta after the International Criminal Court withdrew charges against him. The case against Kenyatta began in 2010 after Kenya's parliament failed to set up a local tribunal to try suspects of the 2007 post-election violence. Following his election as President of Kenya in 2013, Uhuru Kenyatta became the first sitting head of state to appear before the court. Described as shuttle diplomacy, Kenya's foreign minister visited several African capitals, leaving with a promise of their support.
Are we concerned about, some of the things that are happening in the court? Yes, we are. But we've never said we're going to move out. We're a state party. We intend to remain a state party. We need to have some changes made, and we will make those requests at the appropriate forum, which is the Assembly of State Parties.
Most of us here are looking for respect for Africa in the exercise of justice.
And in his first appearance at the African Union Summit, Kenyatta succeeded in rallying African leaders to his cause to have the cases against him deferred and to get the rules changed to give African heads of state immunity from prosecution.
That issue is not legal. It is ideological. And that's how it should be handled. So therefore, this ICC, they are very shallow people there.
Despite getting this backing, Kenyatta attended the court sessions. ICC prosecutor Fatah Bensouda repeatedly accused the Kenyan government of refusing to cooperate with her office, blocking vital evidence. Then, on Wednesday last week, the judges issued an ultimatum to the prosecutor: produce new evidence or they would throw out the case against Mr. Kenyatta.
as they say, one down, two to go. We're nearly there.
On Friday, the prosecutor withdrew the charges, stating the evidence has not improved to such an extent that Mr. Kenyatta's alleged criminal responsibility can be proven beyond reasonable doubt. It had taken 6 years to reach that conclusion. 6 long, frustrating years for both sides. Mr. Kenyatta's deputy, William Ruto's case before the same court is still ongoing, however. Robert Magelo, CCTV, Talk Africa.
Welcome back to the program. So is the collapse of the case facing the Kenyan President at the International Criminal Court a victory for the continent? And what are the short and long-term implications for the ICC and Africa? Well, joining us to discuss this development at the International Criminal Court is Mr. James MAMBOLEO, an advocate of the High Court of Kenya and a consultant with the International Economic Law Center. Also with me here in studio, Peter Kagwanja, the Chief Executive of the Africa Policy Institute. Welcome to the program. Professor Kagwanja, I'll start off with you. Kenya's President Uhuru Kenyatta denounced the case against him at the ICC when the charges were dropped. He called them obviously deficient and a travesty. Now, looking at the way it has all ended, has this been a travesty, and for whom? The continent, for the president, for the suspects themselves, for the victims?
I think the ICC case against Kenya generally is a good classic case of the travesty, or what they call the tragedy, in the Roman history. Tragedy because there was a lot of bravado around the ICC prosecutor saying that he has a watertight case. He has boxes and boxes of evidence. We tended to believe so because he got cartons and cartons from the Waki Commission that were investigated, and we thought there must have been something there. But now, with this public acknowledgement that they have no iota of evidence against Kenyatta, one asks first, why did they drag the Kenyan president through this for 4 years if they didn't have evidence? Two, is the president not entitled to claim justice after that kind of, being dragged, his name, his personality, and his agenda being dragged to the man? So it's not just a tragedy. It is basically a travesty of justice.
James, has this been a tragedy? Your views on that?
First, my congratulations to the President on his personal triumph against the case at The Hague. This is really a big travesty of justice. To start from the bottom up, I would want to say this is a travesty of justice, of course, against the victims of the post-election violence. It is secondly a travesty of justice against the African continent, which is known to be a hotbed of political and other forms of violence. Then thirdly, of course, now at the top is a travesty against Uhuru Kenyatta himself. But these are my reasons for saying this is a travesty. One, of course, the withdrawal of charges against Uhuru Kenyatta do not in any way tell us who, in this particular respect, was actually responsible for the violence that we witnessed in our country in the post-2007 election. But most importantly, it puts the ICC in a very precarious condition in the sense that in future, there might not be a deterrence on the part of any other person who may wish to or who may want to perpetrate that kind of violence in any part of Africa, because they have seen, everyone has witnessed that the ICC process is a big failure. In very few words, that process was a big travesty of justice because it has shown the highest clumsiness of the court, which in my view is not going to really play well in the interests of the general public for which the ICC was created, which is to deter such kind of violence.
All right, James, though, in your view, though, how damaged is the ICC now at this point? Because Africa has often complained of bias from the ICC, one, and secondly, I mean, they had claimed that they had no evidence against the suspects before the ICC. How damaged now is the reputation of the ICC before the eyes of Africans?
The ICC has played the script so well, especially now that a lot of experts have been saying the method of collection of evidence for these particular cases was extremely clumsy. There was really no objective means of ascertaining that the evidence that they had against the suspect was very solid evidence to prosecute those persons. So, in other words, in future, the African continent will be vindicated in saying this court is not serious. It is a court that does not have the proper mechanism of investigating and prosecuting this kind of evidence. So in that particular case, in the eyes of the African continent and the world in general, the ICC really has suffered a major credibility test.
Professor.
And in future, it has really had, it will have to do a lot to bring it back on track.
All right, Professor, is the continent now vindicated?
I think the continent made several charges against the ICC. First, it acknowledged that it has the largest bloc within that court, meaning that there is no premeditated anger or hatred of the court as such. That too, Africa is not immune and does not expect to be immune to international justice, and it is not averse to that. But the behavior of the court in the last 4 years, according to the Africans, and I think they have a lot of truth in that, has targeted a continent. It has targeted a people, the black people in Africa, and it has targeted the leadership, not just the ordinary people. And therefore, it has been seen increasingly as meddling in African politics, too, as being insensitive to the peculiar circumstances in which the continent finds itself with its fragile states and conflicting entities within its polity. And therefore, the ICC is normally seen as the Guantanamo Bay of Africa, of Europe. So whereas America has the Guantanamo Bay, ICC is the Guantanamo Bay of Africa. Look at who is who on that court. And therefore, setting Kenyatta free without evidence and without showing what happened to the evidence that they claimed they had in the beginning, then they are putting themselves in a very, very precarious situation in terms of credibility and in terms of their future as the arbiters of justice on the continent.
But we shouldn't, of course, forget that the judges on this one, on the Kenyatta case, did actually fault the prosecutor. And at the end of the day, it was really about whether they had evidence or no evidence. And the judges came out to fault the prosecutor on this, so it's not entirely the court itself.
Sure, but we have not seen the prosecutor resigning the way we would expect an honorable court to do. On the contrary, she has come out with a lot of indignity, claiming that the Kenya government obstructed her from doing it. Kenyatta has been in power for less than 16 months. He has been in that court for more than 3 years, from December 15, 2010, to April 9, 2013.
Right.
What were they doing? Was Kenyatta still obstructing justice? So she's coming out not as the proverbial sour grapes or so rusa. That's not the way she's coming out as a very uncouth, very uncivil kind of a personality. Because if you have no evidence against somebody, the principles of justice say that you don't say no more. You cannot go putting charges that you cannot bring to court. She had an opportunity to say, I'll indict Kenyatta for obstructing justice. We've not seen that. We are going to indict so-and-so for obstructing the collection of evidence by the court. So she's simply saying those blanket statements, which is not adding to the bad show of the court as far as its performance is concerned.
I'll broaden this very slightly, though. James, though, in your view, as a result of the development in the last week, where does this leave now the continent and the ICC? Because at the moment at the Assembly of State Parties, Africa is saying it can no longer be Africans alone being in front of the ICC. Where does this leave that rather acrimonious relationship?
In answering that question, let me say as follows. Number one, the withdrawal of charges against Mr. Kenyatta is not an acquittal. It is a discharge, which means that the prosecutor really has room in future if the office of the prosecutor collects evidence to bring Kenyatta to trial.
But what are the chances of that, though, in the first place? What are the chances of that happening?
I'm coming to that. Now, in saying so, I'm extremely disappointed, because even if it were possible to bring these charges against Mr. Kenyatta in the future, probably the process will suffer the same failures that he suffered this time around. And this goes back to the question of what kind of investigations were conducted by the Office of the Prosecutor. As it is, we are never going to be sure whether proper investigations were done or whether that Office of the Prosecutor even has the capacity to even conduct those investigations. And this is really why, for the continent of Africa, this is really, really, really disappointing, because in future, we are not going to be assured of the protection in this continent that the ICC was created to give. Of course, you know very well that the reason why this court was created was because it was felt at the time that there was a lot of impediment, especially in domestic legal process, to prosecute people who perpetrated those kind of offenses. And so if at the very start of prosecutions, you know the court is barely 10 years old, if at the very beginning of its active calendar for prosecutions, this is the way it's going to be handling these matters, then the continent of Africa really, in terms of those populations that are vulnerable to the violence that is perpetrated across board, really does not have a lot of hope, in my view.
It is not only about the suspect here in this scenario. What about the victims?
Yeah, that is true. But the ICC pursues a contrary form of justice for the victims from what has been conventional and has worked on the continent. The one form of justice is what we call retributive justice. You want an eye for an eye, a nose for a nose, and the so-called the offending organ must be dealt with. That's retribution, the Hammurabi kind of law. The second form of justice, which has triumphed on the continent and made heroes that we now call our angels, is what we call restorative justice. Restorative justice does not seek to punish anyone. It seeks to restore the society, restore the victim, and rehabilitate the offender, so that the society can come to normal. Where was President Mwai Kibaki in this? Where was Prime Minister Raila Odinga in this? Who said that peace will not be there until X is in power?
All right.
So, in other words, there was politicized from the beginning, and has continued to be politicized. And the fact that there was no evidence to bring Uhuru to trial has now indicated that from the onset, this was a geopolitical issue. And that is why the African continent bought wholesale when they got the story that it is not about justice for the victims. It is about regime change and putting a pliable leadership that they can do business with.
All right. James, your view on this, of course, because some, not all, of course, some African countries still have challenges with their legal and institutional structures. Though, what are the options, though, for victims in the event that something like this happens? Of course, looking at your argument that Africa will be now looking at the ICC with a lot of suspicion.
First, before I answer that question, probably I should give a view on what Professor has just said in terms of the quest for justice. When we talk about what we call retributive justice vis-a-vis restorative justice, probably what I would add is restorative justice is really not necessarily intended on the suspects and victims alone. Restorative justice, to a very large extent, is also projected towards the suspects or the accused persons or the perpetrators of offenses. So the question of restorative justice deals with the question, how do you deal with a person who has either already confessed to the commission of an offense, or who has been found guilty through legal process. And therefore restorative justice comes in to deal with those people, to allow them a chance at reformation and reintegration in society. It is not necessarily a question of dealing with the suspects or the victims, but it will also, to some extent, of course, afford these victims a way of understanding that justice has been given to them. So now, I think the aspect of Africa and where it is going, I may not necessarily say that all is lost probably for the African continent and other hotbeds of violence across the world. Probably this, if taken well, may be a good example to the Office of the Prosecutor and the International Criminal Court in general. They might learn something out of this and say, hey, look, let's relook at our evidence collection techniques. Let's look at our way of finding out how we ought to exercise our secondary jurisdiction. Because remember that the ICC has only secondary jurisdiction. It cannot come in unless the states in question have failed or are unwilling to try the offenses in question. So what, in my view, might happen is that the ICC might go and have a rethink and say, we need to do certain things better. We now understand how, through these Kenyan cases, we understand how the African continent operates, and therefore we may have a chance of interacting with the African continent better in terms of investigation and in terms of probably a prosecution of these cases.
All right, Professor, final word on this, though. Has this been a rather small victory for Africa, though?
It's a victory for Africa, but it's also a challenge for Africa, because the question of impunity continue to haunt the continent. Whether you're talking about Eastern Congo, or you're talking about Somalia as we go now, or South Sudan, those are issues that are going to be with us. I salute the move that Africa is taking, and I hope by January, when they convene for the summit, they are going to set up the Africa Court of Justice. In East Africa here, I think we need to fast track the East African Court of Justice, so that if the country system fails, there should be mechanisms either within the region or at the continental level to deal with these questions. So my word is that it's really an open check for Africa now. They need to write in something useful that is going to deal with, one, the fragility of their state, and two, this perpetual problem of impunity.
All right. James, you have the final word on this.
I think the most important thing we need to consider as a continent is not just a question of creating institutions, but creating institutions with the political will to have those institutions work. I believe that one of the things that Africa should move very, very quickly from is the question of allowing certain persons to run roughshod over everybody else and get away with it. You can see what, for instance, the African Union is trying to do, telling the ICC no sitting head of state is supposed to be tried at the ICC and so on. That's what we should run away from. We should say, let every African head of state and all people in positions of responsibility do everything in their will to make sure that the African continent is working in every respect, and let them make sure that they do not allow their citizens to butcher each other in relation to matters like politics and so on. That is the only way we can get us going.
All right, James, I'm afraid we've run out of time, but James MAMBOLEO, an advocate of the High Court of Kenya and a consultant with the International Economic Law Center, and Professor Peter Kagwanja, Chief Executive of the Africa Policy Institute. Gentlemen, thank you very much for being on the program here on Talk Africa. I'm Beatrice Marshall in Nairobi. Goodbye.
We're nearly there.
First, it is salutary that the sitting president made appearance before the International Criminal Court.
I'm very happy now that the charges against our president has been withdrawn, and now we are ready to move forward as a country.
Anyway, I'm very excited, by the way. So.
The thing whatever happened to the president of Kenya, I can say it's fair, I can say it's unfair. So we can't say anything. We just take it as it is.
I think the AU must withdraw from the ICC because it's biased, it's controlling. They always want to control Africa.
My feelings are that it's quite unfair because our opinion was not aired.
Personally, for me, it seems like they basically targeting all the African leaders.
No matter how big you are, the law is bigger than the person. In a criminal trial of that nature, you must be able to assemble that kind of evidence that is cogent, that is believable, that is compelling.